So, good afternoon, everyone. Welcome to today's presentation. In celebration of Law Day, the Johnson Shoyama Graduate School of Public Policy, or JSGS as we like to call it, and the Saskatchewan Branch of the Canadian Bar Association are pleased to partner on today's event entitled Advancing Reconciliation in the Justice System, Perspectives from the Bench. My name is Merelda Fiddler-Potter. I'm a Vanier Scholar and Executive in Residence at the Johnson Shoyama Graduate School of Public Policy, and I'm pleased to be the moderator for today's event. At this time, I would like to acknowledge that while this event is taking place online, Johnson Shoyama's physical homes are both in Saskatoon and Regina at those two universities. And we are located then in both Treaty 4 and Treaty 6 territory, the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Lakota, Nakota, and the traditional home of the Métis. We welcome those of you joining us from wherever you are across Turtle Island and make this acknowledgement as an act of reconciliation and gratitude to those whose territory we reside on or are visiting. Now, to help our event run smoothly, just a few things that we ask all attendees: please stay muted and turn off your video during the presentation of this event. That just helps everything kind of run smoothly so everybody can hear everyone and see everything being presented. Today's format will go as follows. There'll be some opening remarks. Each of our three speakers will then have a presentation for you, which will take approximately 10 minutes per person. If you would like to ask a question, I'll ask that you send them directly to me in the chat. I will read out as many questions as possible. We do have a lot of attendees today, so we will do our best to answer as many of the questions that come our way as possible. If you have any sort of logistical, technical questions, Karen Jaster-LaForge, who you can see is posting in the chat right now, will be able to help you with any of those technical issues. So Karen, you just message her directly, or you can email her, and the email is there as well. And Karen will keep an eye out for anyone who might be having any technical difficulty. Now, please note that as with all of our public lectures, this presentation is being recorded and will be available for viewing on the JSGS website at a later date. I am pleased to acknowledge one of today's event sponsors, the Johnson Shoyama Graduate School of Public Policy. JSGS is a national hub for the advanced study and research in public policy administration. We are a partnership between the University of Regina and the University of Saskatchewan that was based on the spirit of cooperation and collaboration that defines Saskatchewan. Since our inception in 2007, we have swiftly become one of Canada's leading policy schools for educating graduate students and public servants interested in and devoted to advancing public value. I will now invite Catherine Gillis, lawyer with the Trobert Gillis Law Firm, to bring greetings on behalf of the CBA Saskatchewan. Catherine?
Good afternoon, everyone. I'm so pleased to be bringing greetings this morning on behalf of CBA Saskatchewan. The Canadian Bar Association is a leader and voice of Canada's legal profession, an essential ally and advocate for members of the legal profession. We promote fair justice systems, facilitate effective law reform, uphold equality in the legal profession, and are devoted to eliminating discrimination. The Saskatchewan branch of the CBA itself represents about 1,200 lawyers, judges, notaries, law teachers, and law students from across the province. As the public outreach director for the CBA Saskatchewan branch for the past 4 years, it's been my privilege to assist in the partnership with Johnson Shoyama School of Public Policy to bring this lecture series. This partnership has certainly been of great value to the CBA, our former Law Day activities, and our outreach to both our membership and the public. Admittedly, the legwork of this event and the credit that should be attributed to that work belongs to Karen, Amy, and the school primarily, but we are so honored to remain a part of the conversation this afternoon and help facilitate its presentation to the public. Thank you.
Thank you so much, Catherine. Well, now that we have our greetings in order and we've got all the logistics there, just remember to check the chat if you need to connect with Karen at all. I'm now going to start by introducing you to today's speakers in the order in which they will be presenting. Judge Mary McCauley is a member of the Métis settlement of Cumberland House, Saskatchewan, and is a fluent Cree speaker. Judge McCauley was appointed to the Saskatchewan Provincial Court in March of 2018, sitting in the Cree Court. Prior to her appointment, Judge McCauley practiced exclusively in criminal law while employed with both the Provincial Crown and Legal Aid until starting McCauley Law Firm. Judge McCauley articled with Saskatchewan Justice and was called to the Saskatchewan Bar in 2007. Judge McCauley graduated from the University of Saskatchewan College of Law with her LLB in 2006. Soon after establishing McCauley Law Firm as a sole practitioner, Judge McCauley employed several lawyers practicing in various areas of law. She also articled 2 students at law who continued their employment with McCauley Law Firm. Judge McCauley continued practicing in her firm until her appointment in 2018. So welcome today, Judge McCauley. Judge Pat Reese attended the University of Regina through Campion College from 1975 to 1979, graduating with a Bachelor of Arts, majoring in political science with a minor in English. He then commenced law school at the University of Saskatchewan in 1979, graduating in 1982. Judge Reese traveled through Europe and then articled and practiced law at the Sun and Shine Law Office in Saskatoon from 1983 to 1985. He was then employed as a staff lawyer with the Saskatchewan Legal Aid Commission, practicing criminal and family law at the La Ronge Area Office from 1985 to 1986. At the Regina Rural Area Office from 1986 to 2010, and at the Regina City Area Office from 2010 to 2013. He served as a bencher with the Law Society of Saskatchewan in 2013, was then appointed as a judge of the Provincial Court of Saskatchewan in Yorkton in 2013, and transferred to Regina in 2017. In the past, he has served as the Provincial Court's representative to the Canadian Bar Association and sat on the court's Indigenous Committee, and for a shorter period of time, sat as the court's representative on the Indigenous Justice Committee of the Canadian Association of Provincial Court Judges. He has also presided in the Regina Mental Health Court and Drug Treatment Court and continues to have a particular interest in how these courts may impact the outcomes for Indigenous peoples. Welcome. And finally, Judge Michelle R. Brass is originally from the Pepecasis First Nation of the Treaty 4 Territory of Saskatchewan. Judge Brass was appointed to the Saskatchewan Provincial Court on November 22nd, 2018. She sits in Estevan and on the court circuit points, including Weyburn and Carlisle. Prior to her appointment, Judge Brass practiced law for the previous 20 years. She completed her articles with Saskatchewan Justice in 1997 and was called to the Saskatchewan Bar in 1998. Judge Brass graduated from the University of Saskatchewan College of Law with her LLB in 1997 and University of Regina Department of Philosophy with her BA in 1991. Following her articles, Judge Brass joined the Constitutional Law Branch of Saskatchewan. She then joined Justice Canada in Ottawa, Ontario, where she worked primarily on Indigenous law issues related to the specific claims policy, Crown law, and environmental law related to water. Judge Brass left Justice Canada in 2014 to return home and join the Saskatchewan Water Security Agency. Judge Brass worked solely on water law issues at that stage of her career. However, she decided that it was time to leave government and opened her own firm in 2015. She ran Brass Law Office until her appointment in 2018. Welcome. We are so looking forward to an interesting and engaging discussion this afternoon, and I'm pleased to turn the floor over to our first speaker, Judge Mary McCauley.
Thank you, Tanse. Good afternoon. I'm very happy to be invited to speak here today. Kawesnimineni Dano Tayan, Epigisquan, Teneki, Cumberland House says Taigiche. So we kind of say it a little bit different. But it is an honor to have been invited to speak about my experience as a Cree Court judge. My topic of discussion will be on restorative justice and the spirit of reconciliation within the legal system. specifically in the Cree Court, because that's where I'm sitting, and how we attempt to better integrate the Indigenous legal traditions and language into the courtroom experience. So I looked up a few things, and I'm pretty sure everybody is aware of these terms, but I just wanted to have it there as to tie everything together. What is restorative justice? Put simply, restorative justice can be explained as an attitude to improve a system already in place. If restorative justice processes are working, they should improve all connections and relationships through profound and representative input from everyone. It takes a community to heal a person, and healing cannot be done by the legal system alone. Restorative justice should also create a sense of accountability in the accused and help them understand how their behavior affects the victim and those around them. And the hope is that this accountability will make an accused desire to change. They will want to change. In terms of the spirit of reconciliation, it's about establishing and maintaining a mutually respectable relationship between Indigenous and non-Indigenous peoples in the country. The Queen and Gladue came out, it was a Supreme Court of Canada decision. It came out in 1999, and it emphasized restorative justice as the rate of incarceration of Indigenous offenders was described as an all-time crisis at that time. And the courts were directed to look at an Indigenous offender's personal circumstances and family history when crafting a just sentence so that the sentence can address the issues that brings the offender to court to stop this vicious cycle. And then EPLI, the Queen and EPLI came out in 2012. They found that the problem was much worse, and they called on the justice system to address it. The court directed sentencing judges to ensure that they were not contributing to ongoing systemic discrimination. And once again, restorative justice was reaffirmed, and the court directed the sentencing judges to always consider Section 718.2 sub E under the Criminal Code when sentencing Indigenous offenders, regardless of the severity of the offense. And these are called the Gladue factors. And since the Gladue factors were implemented, there has been no significant change to Indigenous offenders who still have the highest numbers in the prisons. So what can we do to work towards reconciliation in the criminal justice system, especially if it doesn't appear that those numbers are being lowered? I ask myself this question all the time when an offender is in my court. I always look at the individual appearing in front of me as a person, and I'm sure all judges do this, as a person and not an accused. They're someone's son, sibling, parent, or spouse. So how can we implement the spirit of reconciliation and restorative justice in our courts? That's the crucial question. So I'm just going to outline some of the barriers in my court and how I attempt to eliminate them. One of the problems that I see a lot is, and this is in all courts, is court-imposed conditions. The accused is oftentimes released on strict bail or sentence conditions that they cannot comply with. And how can I address that issue in my court? One problematic condition is the residential clause. When an accused does not have a stable residence or no residence, and we are conducting a bail hearing or sentencing, and he has no place to go, I adjourn he or she. What I do is I will adjourn for a few days, not very long, and I encourage the council to seek alternate housing so that they could see if he is released, if he can be released, if he is releasable. If they can't find a suitable residence and he is releasable, I will consider releasing without a residence clause, especially where the public safety is not at risk. Another problematic condition is the abstinence clause, where an accused is clearly suffering from severe addictions. To impose this condition would only set them up for failure, as they haven't been connected to an addictions counselor yet. So the court is required to be mindful of release conditions when releasing an accused on bail. And the reason I'm going into this is because I deal mostly with Indigenous offenders. And the Queen and Zora instructed our courts to release an accused on the least onerous conditions in the circumstances that are sufficiently linked to their risk, and not simply impose conditions, numerous conditions, out of habit. And the Queen and Antic also established guidelines in these circumstances and directed the court to always consider the presumption of innocence, the right not to be denied bail without just cause, and the right to bail on reasonable terms. In other words, the court should not use bail conditions to punish an accused. The problems that I see in the Cree Court in particular is supports. There aren't enough supports in the community to help before and after sentencing. After sentencing, there are supports in Creighton, and there are in Pelican Arrows as well. But during the sentencing process, it's really difficult for them to access those supports. Also, triggers. When an accused is experiencing triggers relating to past trauma or their childhood, and these are the Gladue factors, they have no place to go for help. They have no one to talk to. And I've come across numerous accused that say, I felt my trigger, I was being triggered. I knew I was going to be falling off the wagon, but I had nowhere to go. They also have a lack of trust. The Indigenous offenders, they have a lack of trust in the court and the police. The court is not trusted, and the offender will not turn themselves into police when breaching conditions because they fear they're going to be kept in custody. They don't seek the help when things are starting to go wrong in their life because of this lack of trust. They don't see, a lot of them don't see the court as a place of healing, justice, or restoration. They see it as a place of punishment. And also, there's this lack of continuity, and this is in a lot of the courts. They hear judges, lawyers, and others repeat these old assumptions about Indigenous people, and they're asked the same basic questions over and over again. At times, the Gladue reports in the PSRs, the pre-sentence reports, they're repetitious, not helpful. And when an accused meets an Indigenous or culturally competent lawyer or judge, it transforms their experience, and I don't say this lightly. It means that finally, they don't have to rehash the same old narratives. In terms of jail, we need to be more creative in seeking meaningful sentences that addresses both deterrence and denunciation. Jail is not the only way to address those principles. We can use creativity to seek alternate sentences that basically teach the same lessons. So there's many ways we could go at this. The courtroom protocols, they're intimidating for most people. The courtroom feels overwhelming. The Indigenous people come there at 10 a.m. There's so many cases, they're sitting there all day long. And frequently the court is held up by a variety of factors. There's missing people, missing documents, miscommunication, and matters getting adjourned. And this waiting tends to increase the anxiety, the expectations as to what can happen. Their matter is then adjourned to the next court day. It creates a lot of drama for them. There's no closure. The anxiety itself can fuel more offenses, restarting the whole cycle. And especially the court process it's excruciating for people that have memory issues, they have undiagnosed or untreated mental health issues, addictions issues, cognitive disabilities, and those who are struggling with everyday survival. So these are a lot of the issues that I see. And in terms of what practices we've implemented, what we try to do in the Cree Court is we try to make it easier for the accused, and not just the accused, for the complainant as well, to be able to contact any of the appropriate court party without making them jump through all the legal hoops. We try to encourage texting, email, Facebook are a few examples. Just in Sandy Bay, we couldn't reach one the other day. We couldn't reach an accused, and I called him on my cell. And he was kind of surprised, and he called me back and he said, "Hi, Mary. Thank you for calling me, Mary." So I said, "Okay, we've adjourned your matter over to the next day or to the next court day." So the reason I do this is we don't want to see bench warrants. And a lot of the times they shouldn't be in custody for a fail to attend court. So we try to do everything in our power to help fast forward, even in terms of the legal aid applications. We'll make them apply right there and then. In terms of the Cree language, and I know this is a biggie in the Cree Court, we do have interpreters always available for sentencings and trials when requested. I allow the accused or complainant to speak in Cree during the court process. I try to speak in Cree as much as possible, but one of the issues we have in the Cree Court is we don't have a Cree speaking Crown. We don't have a Cree speaking defense lawyer. The police officers don't speak Cree. So speaking in Cree all the time is really difficult because I have to start interpreting everything, and it's very time consuming. And nobody would know what is actually being said, but with the exception of the judge, the accused, the Cree Court clerks. So that's something really that's required is more Cree speaking staff, more Cree speaking lawyers. I always speak Cree when I'm in the community. I always let them know that we are there to assist in whichever way we can. I know I'm the judge, but I'm there to listen also, and I want them to know that. I prefer a relaxed atmosphere in my court and not a formal setting. I use humor at times to show I'm relatable. If a person doesn't find me approachable, not much can get accomplished. And I often share personal experiences and anecdotes that are relatable to show that they're not alone. I try to tell them what I did to overcome my situations, the hardships in life, and how I got to where I am. And it's okay not to always have all the answers. I want to show my humanity and not the gavel of punishment. Even though I'm required to sentence them, I could do it with mercy and I could do it with compassion. I've had many offenders come back to me later and they say, Judge McCauley, I remember what you said. It really spoke to me. While judges are expected to be neutral, I find that neutrality sometimes is a detriment when I have something meaningful to impart. So I try to pass on my personal and Indigenous experiences as much as possible. I allow their family to sit with them when their name is called. I ask the police to remove their handcuffs when they're in the courtroom, when and where it's possible, depending on the risk. We don't conduct enough sentencing circles. I would love to have more of them. They're significant to healing and reconciliation and restorative justice. We encourage pre-charge diversion on appropriate pending charges. I encourage pre-charge diversion on ticket matters, and after successful completion, I encourage the RCMP to withdraw tickets so that it doesn't interfere in their ability to get their driver's license. We encourage informal mediation on certain charges. And because we don't have a domestic violence court in the North, we find other ways to be creative. And the Crown and defense are excellent on this. The accused will be asked to attend counseling or addictions programming, as this may impact their sentence in the end. We encourage the police to consider the release of individuals on minor breaches and serve them with a promise to appear, as opposed to keeping them in custody and bringing them into court. So as you can see, there are many issues in the legal system that can be improved. We have done our best to make the changes where possible for better access to justice, but of course, there is a lot more that we can do. But I am hopeful that in time and with the effort of everyone that's involved in our legal justice system, that we can work together to make restorative justice and reconciliation more of a reality. Eglise, Taigiche, Diniki. That's my, thank you.
Thank you so much, Judge McCauley. I'll just remind everyone, if you want to send questions, you can send them directly to me in the chat. We will get to questions right after the next two presentations. And now I will turn to Judge Fries.
Good afternoon. Can you hear me, Mary? Okay, good afternoon, everybody, and thank you to Judge McCauley for that talk. I said at the pre-planning meeting that the quality of our court has gone up significantly with the appointment of Judge McCauley and Judge Brass. So there you go. Before I begin, I'd like to thank Justice Neil Robertson of the Court of Queen's Bench, who always seems to find a way to get me involved in these. and to Amy Zarzeshny of Johnson Shoyama for inviting us to speak today. It's always a pleasure. I'd also like to thank the CBA Sask for co-hosting today's event. These kinds of conferences are important, especially when you think about, what is going on in the world today, including justice systems that are failing. We cannot take our justice system for granted, and all of us need to keep working on it. So kudos to everyone involved in the planning of today's conference. Now, in the past, when I've given talks, at the beginning, I announced that there will be prizes that tend to incentivize participants to listen a little closer. But today I've decided to use a little different format. There will be prizes, but rather than a question and answer at the end of my presentation, I wanted to use a different approach. Just so people know, the prizes will be our book, The Evolution of the Provincial Court of Saskatchewan, if you can see that. I will be awarding 2 prizes. I see from the registration list that Melanie Hodgins Neufeld is listed twice. Is Melanie with us today? Okay, that doesn't matter. Since Melanie was so interested in the conference by registering twice, she'll be receiving one of our books, and I'll make sure that she gets it. The book is written by Amy Jo Eman, and it's a very good history of the Provincial Court of Saskatchewan. The second prize will be based on geography. I see from the registration list that one of our participants today comes from New York. Is that correct? That is Isla Dowling. I think I know who she is, but I'm not sure. But given that you're participating all the way from New York, you'll be receiving the second book, and I'll make sure that you get it, Isla. Turning to today's topic, reconciliation and the justice system is a very broad topic, as we all know. So when I was thinking about what I could talk about today, and drawing from my experience sitting in the past in the mental health court, Regina Mental Health Court, and Regina Drug Treatment Court, I couldn't help but think about, firstly, the devastating and disproportionate impact that the drug overdose crisis has had on Saskatchewan's and Canada's Indigenous peoples, and how the justice system might respond to that. Secondly, I kept thinking about the negative impact for the past 2 years of COVID-19 on people, including Indigenous peoples' mental health, which includes depression, more specifically major depressive disorder, which is increasing. So I think it's important to understand that sort of curve in the road that we're all going to be seeing. Simply put, I believe that the therapeutic courts of Saskatchewan have a bigger role to play now and in the future, so that we can have better and more restorative outcomes for people within it. By way of background, there are more than 100 therapeutic courts in Canada. In Saskatchewan, we have 8 therapeutic courts, in addition to what Judge McCauley has shared about the Cree Court. We have 2 drug treatment courts in Regina and Moose Jaw. with planning for one in North Battleford, which will be very good. We also have 3 domestic violence courts in Regina, Saskatoon, and North Battleford. And we also have 2 mental health courts in Regina and Saskatoon. Broadly speaking, therapeutic courts are characterized by active judicial involvement, and I must say gratifying, working with other professionals to motivate individuals to accept needed services, the monitoring of individuals' compliance and progress, and individuals are sentenced after they have stabilized in the community. Focusing on mental health and drug treatment courts, the mental health courts in Saskatchewan help address the overrepresentation of people with mental illness and or cognitive deficits in the criminal justice system by focusing on the underlying problems that often contribute to the repeated criminal behavior. Judges, prosecutors, legal aid, and other lawyers, community corrections, and community and healthcare agencies can make referrals to the mental health courts. A designated Crown prosecutor acts as a gatekeeper for referrals to the court, as they do in the drug treatment court. With respect to who can be referred, they must be adults who have been charged with certain provincial or criminal offenses, with some offenses excluded, that are willing to enter a guilty plea and have their sentencing delayed. The Crown prosecutor is seeking a sentence that is less than 2 years in jail, and the offenses appear to be linked to ongoing mental health challenges, psychiatric disorders, traumatic brain injuries, fetal alcohol spectrum disorder, or other cognitive issues that impair judgment. The court process pre-COVID, when we used to meet in our library, involves a pre-court meeting, now by telephone since COVID, with the Crown prosecutor, legal aid, counsel, probation officer, community and health care workers, along with the judge. So since COVID, we have adapted, and only the Crown and the defense and the judge appear by telephone to discuss participants' progress or lack thereof. Prior to, we'd meet in our library, sit around the table, have a cup of coffee, talk about participants. And it was a really good system, because sometimes people would come to us unknown to anybody, but then somebody around the table would say, I know that person, and here's what's going on with him or her. So we hope to get back to that system in the near future. In any event, at the pre-court meeting where the participant is not present, an update is provided with respect to each participant, and a case plan for the upcoming weeks is developed with a focus on what can be done to help that participant and to protect the public. Oftentimes, those discussions focus around residence, where to live, hooking the person up with a family doctor and or psychiatrist, staying on meds, seeing that people have enough to eat, things that are pretty basic to us and taken for granted. In any event, motivating the participant is always of the utmost importance. We hold court every second week with a smaller docket size, between 5 to 15 participants, and the judge will engage in a discussion with each participant. I no longer sit in mental health court or drug treatment court. Judge Noah Evanchuk is now. I may go back. Judge Hines has sat there, and Judge Todd has sat in the drug treatment court. In the mental health court, I have engaged in discussions with participants about whether or not the Pittsburgh Steelers are the best NFL team, whether near beer is actually beer when we think about conditions of release, things like that. You develop a rapport with the participant and they gain your trust. And it's an amazing process. During the interaction, I and the other judges will encourage compliance with the participant plan and may require promises. We have set steps in the mental health court after a person is admitted, including getting a lawyer within 2 months. Legal aid duty counsel is available to all accused. And within about 4 months, the accused, working with their lawyer, should enter a guilty plea. As with the drug treatment court, it's important to keep in mind these are sentencing courts, not trial courts. They must sign an agreed statement of facts, waive the right to immediate sentencing, sign a consent to obtain medical, psychiatric, or psychological reports, sign a participant plan, appear in court from time to time as required by the judge and the team. This is a team approach, as is the drug treatment court, and share information on their well-being with the team. After about 12 months, the Crown Prosecutor and Defense Counsel will consider making sentencing submissions to the judge respecting the accused, and the judge will sentence the accused. Successful completion of the mental health court means adhering to the conditions of the participant plan, having a stable residence, being connected to healthcare providers, and community supports and stability in the community with no new charges. Successful participants often receive a non-custodial sentence, usually a short period of probation or a conditional discharge, and in rare cases, a conditional sentence. One thing the stats do not show and will never be able to show is that it's always been my view that we'll never know which person afflicted with a mental health issue did not participate, to put it bluntly, in the death of somebody over a weekend. We'll never know that because of their time in the mental health court. Perhaps we have prevented greater tragedies that we will never know about, is my point. Now, with respect to the drug treatment court, it's quite a different court than the mental health court. In Saskatchewan, as we all know, drug addiction, recently crystal meth, and speaking about fentanyl for a second and the overdose crisis, these particular drugs often bring people into conflict with the criminal law. And experience has shown that in many cases, until the underlying causes of criminality are addressed, conflict with the law will continue. Drug treatments court offer a therapeutic option to address the drug addiction as an underlying cause of the criminal activity. The goal of the drug treatment courts is to assist offenders in finding sustained sobriety and address other criminogenic needs to break the cycle of involvement in the criminal justice system. Success in finding sobriety through a wraparound program offered in the drug treatment court will reduce recidivism, lessen the pressure on the health care system through healthier lifestyles, and have a positive effects on the individual, families, and communities as a whole. Drug treatment courts operate using a collaborative model. The court handles a specialized caseload and again requires a dedicated judge, Crown prosecutor, legal aid, duty counsel, probation officer, drug treatment court manager. In Regina, it's Judy Burns, addictions counselors, nurse, that's a psychiatric nurse, and a social services professional working together as a team. I enjoy this work, not only because of the many positive outcomes that I have seen, but because, like the mental health court, we work as a team. By way of background, the Regina Drug Treatment Court started sitting in November of 2006. Judge Clifford Toth, working with other professionals from justice, health, prosecutions, legal aid, and probation, made this possible. The Regina Drug Treatment Court received 50% of its funding from the federal government and the provincial government, provided by staff secondments from the Ministries of Health, Addictions, Counselors, and Nurse, Corrections, Probation Officer, and Justice Manager. The Regina Drug Treatment Court involved a merger of law and health. Yesterday I sent out a video, not a very good one, I did it myself, of what we call the Hope Stick. And if you take a look at it, well, it speaks for itself. Please take a look at the Hope Stick. We came up with the idea, and I had a local carver commissioned to do it. Because of COVID, it's over 6 feet long, and I can congratulate the graduates from the Drug Treatment Court. In any event, the court involves a merger of law and health. It's funny when you first get involved in this court and you participate in what we call, Jan Turner is there. I see her name up there. In any event, when you participate in meetings every 3 months to talk about what's going on in the drug treatment court, you almost speak a different language. People in justice, lawyers, etc., speak differently than people in health, and that's not a bad thing. You're just learning new ways of speaking, so it's quite interesting that way. And in any event, I was looking for the words oversight committee. With the merger of law and health, this requires professionals from different disciplines to communicate with each other, work together, and to commit to an innovative program in court. We have a drug treatment center on Albert Street. It's a wonderful facility, and I think it's a must to have. Judge Hines joined Judge Toth in 2009. And then in 2017, Judge Toth retired from the court, and I agreed to help Judge Hines out. And then I began sitting in it. On June 30th, 2020, the Regina Drug Treatment Court celebrated its 99th, 100th, 101st, and 102nd graduate. We're very proud of that achievement. We have compiled a bench book that sets out all of the information and procedures used in drug treatment court. And we also refer and rely on extensively the National Association of Drug Court Professionals, NADCP Judicial Bench Book, and the standards that they have developed. The Americans are ahead of us on this, and we rely on the work that they have done. They started in 1989. Referring a little bit to our bench book and knowing that time is marching on, our target group are offenders who are addicted to or highly dependent on illicit drugs and at a high risk for criminal recidivism or failure of less intensive rehabilitation dispositions. We have an eligibility and referral process that I don't think I'll get into other than to mention again that the Crown is the gatekeeper. Most of our participants come from custody, from the Regina Correctional Center, but a lot of our participants have come by way of Estevan through Judge Brass, through Judge Koski in the Yorkton area, and even up in Prince Albert. Initially, after a person is released, there's a 30-day assessment period, and then participants participate in 3 separate, distinct, and graduated tracks, which they are required to complete before graduation. Drug treatment court is only available for certain offenses. Some are excluded, and usually offenders are facing a custodial sentence of between 12 to 30 months in jail. We use what is called a deferred sentencing model, which subsection 720 sub 2 of the Criminal Code allows. Also take a peek at subsection 10.4 of the Controlled Drugs and Substances Act. Sentencing occurs when the participant either successfully graduates from the program or is discharged. We do have some failures, sadly. We also have deaths, very sadly. So it takes some stamina, not stamina, but you got to be tough to sit in this court, because once in a while you lose somebody who you've gotten to know pretty well over 12 to 15 months or a shorter period than that. In any event, we're very proud of our court. I think I'm running out of time, so I won't get into the process, the pre-court meeting, and what happens in court. But I do want to say in closing that while our numbers have remained fairly stable through COVID in the mental health court, we're always on the lookout for people in the drug treatment court, and I'm sure they will come. With that, I intend to close. I have lost track of time, Merelda. Am I right?
You're perfect. Thank you so much, Judge Reese.
But I'd be pleased to answer any questions later.
Absolutely. Yep. And people are starting to send me questions. So thank you so much for that. I will keep that question list handy as soon as we are done with our next presentation. I will now turn it over to Judge Brass.
Thank you.
I just want to thank my sister and brother judges for providing us their perspectives on the advancement of reconciliation in the justice system from Drug Treatment Court, Mental Health Court, and Cree Court. I also want to thank JSGS for inviting me to this Law Day event. It's an honor to be here and to share my perspective as well from the bench on the topic of advancement of reconciliation in the justice system. I also want to acknowledge that I'm currently sitting in my own territory, traditional territory, which is outlined in Treaty 4, and as well as the homeland to the Métis people within this territory as well. I'm going to be taking a little bit more of a broader approach when I'm in my presentation. I was thinking about that topic, advancing reconciliation within the justice system. And so I looked at definitions of reconciliation, and my sister, Judge McCauley, had mentioned already that this means that it's a process of establishing and maintaining a mutually respectful relationship between Aboriginal or Indigenous and non-Indigenous peoples within the country. In our case, we're now focusing on Saskatchewan and the justice system of Saskatchewan. But I also want to quote the Honourable Murray Sinclair when he indicated reconciliation is not possible until there is mutual respect. So that's sort of in the back of my mind as I'm thinking about this topic. If we go back to the TRC or the Truth and Reconciliation Commission, of course, there's the 94 calls to action. And there are a number of areas that were covered, such as child welfare, education, language and culture, justice, and equity for Aboriginal people in the legal system. There are a number of other issues as well that were discussed within the calls of action. But I just want to focus just on one for now, and that's call to action number 27, where we see it says, we call upon the Federations of Law Societies of Canada to ensure that lawyers receive appropriate cultural competency training, which includes the history and legacy of residential schools, the United Nations Declaration of Rights of Indigenous People, treaties and Aboriginal rights, Indigenous law, and Aboriginal and Crown relations. That's a pretty big topic, pretty big nut to crack. But for the lawyers in the room, you'll be pleased to know that you actually get 1.5 CPD ethics hours for attending today. So that's a bit of a promotion for encouraging lawyers to attend talks like this one that's being held today. From my perspective on the bench, when considering reconciliation for establishing and maintaining a mutually respectful relationship between Indigenous and non-Indigenous people in this province, I want to observe a number of things right up front. And first off, that there have been 5 Indigenous judges who have been appointed to the Saskatchewan Provincial Court, I believe since 2018. I don't know if there was anyone from 2017, but I believe it was 2018, which included, of course, Judge McCauley, myself, Pelche, Gibb, and then Justice Crook, who was later elevated to Queen's Bench shortly afterwards. Prior to that, there were only 2, which was Judge Trapel-Lafond and Belrose. For the majority of the provincial court's existence, the presiding judges did not have Indigenous people as peers and equals. Rather, most judges had before them Indigenous people who were either accused and convicted or convicted individuals or victims. Convicted individuals and victims, sorry. So naturally, a mutually respectful relationship has been difficult to establish under those conditions. With more Indigenous judges being appointed, I would say that the initial steps towards the advancement of reconciliation in the justice system is being made. With the appointment of more Indigenous judges, establishing the foundation for a mutually respectful relationship can be more naturally maintained by observing some examples, and they include, for example, the provincial court no longer is made up of only judges who are non-Indigenous people. The provincial court judges now have Indigenous judges who work as peers and equals. The provincial court now has judges who have a deeper and personal understanding of Indigenous people who are before the court, although I'm not trying to undermine or disregard the genuine understanding acquired by most of the non-Indigenous judges. And Indigenous youth have Indigenous role models with the newly appointed judges on the provincial court. And Indigenous people now have Indigenous judges presiding over their matters, and they now see that their own Indigenous people in these lead roles in their communities. And in turn, non-Indigenous people also have Indigenous judges presiding over their matters and can also see that Indigenous people are in these lead roles in their respective communities as well. I also want to observe, though, unfortunately, that not all judicial centers have sitting Indigenous judges where Indigenous people are more commonly found, which is unfortunate. And the gaps that are on the path towards reconciliation in the justice system are more readily observed from the bench. They're also observed in other perspectives as well, as you well know, in universities or in the workplace or in mainstream society. Gaps can be seen. The gaps that we can see from the bench itself relate specifically to the justice system itself. But news of my own stories or experiences that I've had since being appointed to the bench. And I believe that these experiences demonstrate that reconciliation in action is actually happening. So for example, when I was first appointed, I was thankfully able to start in Regina for the first few months. I did have a lot to learn, given that my background was more in Aboriginal law, Crown law, water law, and very limited in criminal law. Thankfully, I was able to be with my brother and sister judges in Regina to gain their experience or to ask them questions. And then I also had to relocate to Estevan after I was appointed. But for those first four months that I was in Regina, within the first few days of sitting in Regina, I could see surprise and curiosity on the faces of the people who were in court. And that included the Crown's defense counsel, court staff, the deputy sheriffs, and the participants, whether that be an accused, an offender, or a victim, or family members of those participants. As well, in the Regina Youth Court, after a few days, I had Indigenous kids asking for me. I suspected that this was because it was much easier for Indigenous youth to be standing before a judge who probably looked like their cookum or their grandmother, assuming that I look that old, maybe their mother, I don't know. Or a person who may have had a better understanding of where they come from. And I would say with my own background, I certainly do have a deeper understanding of where a lot of the kids or people who are Indigenous people who are in court, whether they be from reserve or rural or urban Saskatchewan. Also in Regina, I remember seeing Indigenous parents and grandparents nudging their child or their grandchild and subtly pointing to me as if they were saying to that person, see, you can do it too. We can do this. You know, we are able to be lawyers and judges. And for a person, especially a young person, to be able to see that in the flesh, I think has a huge impact on their worldview. And it's not so small, it's expanded by seeing us sitting there and helping them through their process that they're in. In Estevan, where there are few Indigenous people, I have had non-Indigenous people do double takes when they first saw me. My presence seemed to be a shock and surprise to some accused, offenders, police officers, crowns, and other court parties. Sometimes the shock was negative. You know, I had people who looked like they were angry with me sitting there, or I had people get red in the face and leave the courtroom quickly. But other times, and I would say more often, the experience was very positive. So occupying the seat at the bench has opened the eyes of court participants for those who were not acquainted with Indigenous people who had reached this level in the justice system. In Estevan, which is also within my traditional territory, where my people have existed for thousands of years, as opposed to the justice system, which is relatively new, I note a gap of knowledge, or rather lack of knowledge, about the local Indigenous groups. There's only 3 down in that area. There's White Bear, Pheasant Rump, and Ocean Mound. Those are the 3 reserves down in my area where I sit. And I've caught wind that there's sometimes a deep lack of interest to learn anything about the Cree, the Saulteaux, the Nakota, and the Assiniboine people of the area, from the non-Indigenous peoples down in that area. So this gap reminds me of the education that non-Indigenous people received about Indians back in the day. And I can see how that old teaching still remains strong in some people yet today. So filling that gap will take some time, but some of those steps towards filling that gap is having people like myself or my fellow Indigenous judges on the bench to show that we are able to do this. This is our territory, and we can fill these positions as well, just as well as anyone else. And so I think it expands people's minds when they actually are exposed to us. I also want to note that when a person is standing before the court and is met with genuine understanding and a concern about their predicament that brought them before the court, and that genuine understanding and concern from the judge, trust and respect is generated, whether that person be Indigenous or non-Indigenous. So I believe these are examples of where the advancement of reconciliation are being made But there is much work that needs to be done yet. And this is a long process. Things will not happen overnight. But I believe that with the appointment of Indigenous judges to the Provincial Court, that steps are being made to be able to expand people's minds and to make people more comfortable and to be able to generate trust and respect so that a mutually respectful relationship between Indigenous people and non-Indigenous people may be established and maintained with our continued involvement within the justice system. So those are the perspectives that I wanted to share. It was much more broader and just to approach reconciliation from the real experiences that I've had myself on the bench. So again, thank you very much.
Thank you so much, Judge Brass. People can now start to send me their questions. I have some questions in the queue already, so I won't wait at all. I'll get straight to the questions. This first question goes to Judge McCauley, and they say, I heard you say you encourage pre-sentence diversion. What are your views on pre-charge diversion? As a former police officer, having worked more than 8 years in the high Arctic, I found pre-charge diversion worked really well for the community, but I don't see a lot of it happening in Southern Canada.
Well, that's a very good question. And we do see a lot of that in Pelican Arrows, and we see a lot of that in Sandy Bay. So there are a lot of charges that don't even make it to the bench. They don't even make it into court. And the RCMP in those areas are working with the accused. And normally it's on matters that would be referable to alternative measures. And they work within the community, with the community members. They attain the level of success at what they're looking for. They're talking to counselors and whatever else is required of them. And a lot of times these charges don't come to court. So I think that's the perfect example of reconciliation and restorative justice. If these charges don't have to come to court, and you could deal with these, whether it's youth or individuals that have no criminal records, or maybe even people that do have criminal records, but it's something that is within the ambit of alternative measures, that's something that should be promoted. And that's with the RCMP, and we have a lot of that in Pelican Arrows and in Sandy Bay.
Thank you so much, Judge McCauley. Judge Brass, this question comes to yourself. One of our viewers wanted to ask, what is the smudging protocol in provincial courts? What does that look like? How does it work? How do people access it?
Well, Court Services does have a procedure in place where people can make requests to have a smudging ceremony within the courts. So the first place that a person should go to is to consult that policy itself. And that's the first step. For the provincial court judges who are also working on the process and procedure in which they would be following, that's something that's in the works right now. And it has to be a policy that acknowledges judicial independence. So it can't be just assumed that smudging will occur. There are a number of things that need to be taken into consideration. But if you look at the court services policy, for example, if it's a building that is solely within the provincial court, it may be more easily completed within a building like that. If it's a building where it's not owned by the provincial court, then there's issues of the other tenants within the building, whether it's possible. There's health concerns as well. If people have allergies, for example, that needs to be taken into consideration. But when there's a request made, the judge will take into a number of factors of including the court services policy, but also any concerns for judicial independence that the bench itself will be concerned about. And I know that I've provided you that policy, so I'm not sure if you're going to share that or make that available.
Perfect. If Karen has that, Karen will share that for sure. Thanks so much, Judge Brass. Judge Reese, one of the questions here says, when you're working with teams that include healthcare professionals, how do you manage the legal aspects and the health aspects in drug treatment court?
Well, first of all, I try to, when I first started, figure out the language. Like I said, it's not a bad thing, but people in healthcare almost speak a different way than people in the justice system. And because you go to law school and you're a lawyer for 28, 29 years, and then a judge, you speak in sort of justice language, right? So you sort out what people mean when they say something. But I must say that this is that through my work with the Drug Treatment Court and working with the Saskatchewan Health Authority, there is a real desire on their part, as is there with people from justice, i.e. the Crown, legal aid, and the judge, for people to succeed in the Drug Treatment Court. So you figure out the language, figure out a way that people are going to succeed, and you cooperate, and it works. One thing I didn't say about the Drug Treatment Court is that it works, and the common goal is reached in most cases. That's not a problem. You just sit down and you talk. And we used to meet over at the Drug Treatment Center every 3 months in a nice room there called the Sunroom, and you sit around in a circle and talk, everybody, and it works really well because everybody is trying for the common goal to have this person graduate. So you come together.
Thank you so much. Back to Judge McCauley. This question comes in. It says, are Gladue reports used for Métis offenders in your courts? If not, what would you suggest to increase the writing of Gladue reports specifically for Métis people?
Well, the reports, it covers the First Nations and the Métis. I don't see very many of the Gladue reports per se. Where it's the actually comprehensive Gladue report, but what we see a lot of is the Gladue portion in the pre-sentence reports. So we see a lot of that, and it's for any Indigenous person, and Métis, it doesn't matter. But sometimes, unfortunately, it's almost a cut and paste. And you see that in the PSR report, the Gladue portion of the pre-sentence report. It's almost a cut and paste, and then there's a few blurbs in there about their upbringing. So I find that it's not comprehensive enough. It needs to be more personal, and it needs to be more, I guess, where it helps and how it explains how they got to where they are. And I don't see enough of that in the Gladue report, in the Gladue portion of the PSR. And unfortunately, I haven't seen very many of the Gladue reports either, other than the ones that were funded privately, where they pay for it themselves. I don't know if that answers your question.
I think so. And just as a follow, another individual asked, do you think that the current state of Gladue and its application is addressing some of the over-incarceration rates we're seeing? And that was directed to all three of you. So what I'll do is I'll start with Judge Brass, and then I'll move back to Judge McCauley.
Sorry, can you restate that question?
Yes, the question is, can you speak on the current state of Gladue and its application in Sask courts, and is it addressing the rates of over-incarceration of Indigenous youth and adults, or do you think it is?
Well, I think if you look at the statistics, it would be hard to argue that it actually is addressing the rates. I don't believe that the rates have actually gone down. There is continues to be a high rate of Indigenous people in courts and in the jails within Saskatchewan. The Gladue reports, I have not seen any myself, maybe because down in Estevan there are very few Indigenous people. I have seen the PSRs that do include sort of a trumped up area that considers Gladue factors. And I have to agree with Judge McCauley that it's lacking in terms of information. One of the things that I always ask, I mean, we could look at a person's background and explain why that person is brought before the court, but the flip side, or the next question that needs to be answered, what resources are out there in the community that can be put in place on sentencing that will not have the person go into jail, but may go, we put on a sentence that includes something within the communities. And so I'm not sure exactly whether that's a gap within corrections within the province, and possibly a lack of communication within Indigenous communities and what may be available out there, if anything at all. And I think that if there were that a connection of what's available in the communities, because I've asked Defense Counsel, have you been in contact with the tribal councils or the band offices? And actually some lawyers didn't even know that they could actually make that phone call. So again, that was a lack of knowledge on Defense Counsel's side to realize they need to pick up the phone and talk to the justice systems within the tribal councils and bands to see if there's anything available there that would address that second component for the Gladue factors. And I think that that might assist with bringing down the numbers. But I mean, this is something that will take time, and but currently, I don't believe the Gladue reports, at least from what I've seen, are not in existence. The PSRs do have that one component that is of some assistance, but more can be done.
Judge McCauley, Judge Reese, do you have anything you'd like to add?
Can you hear me?
Sorry,
Yes.
Go ahead, Judge Reese.
My experience in Regina has been, since probation services has implemented changes to the pre-sentence reports, that they're doing a better job of giving the court the information it needs with respect to Gladue factors, but it depends sometimes on the writer of the report. But overall, I have seen an improvement. The other thing that can be done is that, of course, we know this, but the public may not know, is that if you think the report is deficient on the Gladue factors still, you can ask for more information. But the other thing about Gladue is this, and I've always thought this, when Gladue came out, it put a lot of obligation on Defense Counsel to bring forth these factors. And I don't know what other defense lawyers do, but when I used to meet with clients, I would say to them, I want you to write up your whole, explain Gladue to them, and I'd say, I want you to write up your whole life history for me, you know, at your kitchen table some night, and make it 20, 30 pages, double space it or whatever, and I'll decide what I think the judge needs to hear from you. But, and I'm not trying to beat up Defense Counsel, but sometimes, in my view, Defense Counsel is not providing enough Gladue information. Some do a very good job at it. Sometimes it's hit or miss, right? But the other thing in the context of the question raised is, I think people need to keep in mind that when Gladue in the later case of Ipoli came out, the Supreme Court did not tell judges how to do this. And I got to be thinking that they did that intentionally. They wanted judges to figure it out. And case law would develop around it. But, and this is a compliment to our Court of Appeal, since cases like Chinookwa, Slippery, Whitehead, JP, the Court of Appeal has actually given us some guidance as to how to do it, right? So I think that's an important part of the discussion. But final word on it is, aside from the mental health court and the drug treatment court, when I'm imposing a sentence on an Indigenous person, if people think it's an easy task, it is not. You wrestle with it. So it's not an easy thing. That's about it.
Judge McCauley, do you have anything else to add on the current state of Gladue and its application in the courts, given our over-incarceration rates?
Well, I agree with Judge Brass. The numbers are still high. So not to sound like I'm nitpicking here, and that's not because we've made leaps and bounds in addressing those Gladue factors. But one of the issues that I see a lot is this repetition of what's wrong with a person. This is what's happened to him. This is how he's come to this place and time, and then that's it. We can't just point out the problems without having the resources there to say, okay, here's the problem. We also have to say, okay, here's the problem. Now, how can we actually meet that need? So I know in the drug treatment court in the city they have that opportunity. We don't have that in the north. They have addictions counselors. It's not intensive. Sometimes it's AA. So it's not something that's, and in order for them to go and get a really in-depth treatment, they'd have to go to Prince Albert. They'd have to go to the city. And that's just not something that's feasible in terms of poverty. So we could name all the problems that they have, but unless we say, here's the answer, there's not a heck of a lot we can do about that. So, and I know the courts they're very good. And I know I'm talking for Prince Albert in our area, and I'm pretty sure all the other courts are the same, as well as the Saskatchewan Court of Appeal, but they do very well in covering the Gladue factors. They put it into their sentences, and they try to reach that restorative justice and that reconciliation. But sometimes in terms of the actual resources that are available, it's really difficult to get some of these people, the Indigenous people, the offenders that need it the most. It's really hard to put them into that intensive program that they need.
Thank you so much. There are a number of questions coming in. We will try to get to as many as we possibly can. Judge Reese, this question comes to you. What role, if any, can the drug treatment court play in the opioid crisis currently facing many Saskatchewan communities?
Well, please don't take this as a criticism of people that are referred to the drug treatment court. Some offenses are excluded by their very nature. If I could use as an example, say gun charges. Oftentimes when the police arrest, say, a group of 4 or 5 individuals and they're charged with an offense, often all of them are also charged with a gun offense. All of them are charged when maybe at the end of the day, only one is responsible for the gun. You can argue parties and all this stuff till the cows come home, but maybe if the Crown looked a little earlier at what that person's involvement may or may not have been with the gun, say, that excluded them from the drug treatment court, perhaps that person could participate and do well in our program. That is not an easy thing to figure out early, though, sometimes when I'm sure when a Crown is looking at a file and it's not clear who was involved with the gun or whether they were a party to the gun. Now, I don't mean this as a criticism of the Crown, because these are difficult decisions to make early and well before lots of lawyers are involved with each individual. So it's not an easy process, but I think there is a role for the drug treatment court if we can find a way to open the gates a little wider for certain people to participate in the program. I expect that many of them would do well and not be found dead in the back alley, right? But the Crown is doing their best. It's not meant as a criticism, it's just a thought. So there is a role, yep.
Thank you. This question is directed to all the judges. So maybe Judge Brass, I'll start with you this time. I'm interested in hearing the panelists' perspectives on what they would want to highlight for policymakers and researchers in terms of advancing reconciliation in the justice system.
That's a pretty big question.
You can have it.
Okay. I think I kind of touched on it when I gave my presentation. Participation of Indigenous people in all sectors of society is important because it generates a realization in people that we are peers and we are equals. And I think that policies should acknowledge that when there is a group of people who are excluded, whether that be Indigenous people, women, people of color, whoever, that their exclusion removes that one important accomplishment of having us as peers and as equals. And this is something that's been sort of, I've discovered throughout my entire career, whether that be as a judge, as a lawyer, as just a worker anywhere, being involved and included. So I think that since this is such a broad and big question, so I'm going to give a big, broad and expansive answer and say that inclusion of people in all areas of wherever, whether that be an institution such as the university or in the justice system or wherever, including people as equals and as peers, and to not exclude people. And so to miss out on that opportunity, I think is key.
Thank you, Judge.
Can I weigh in there?
Absolutely. I was just about to come back to you guys.
I agree with Judge Brass, but I'd like to sort of piggyback on Judge McCauley's comments. We need more treatment options, especially in the north, where I used to be as a young man, and I love the north. Secondly, I think we need to find a way to factor in more Aboriginal approaches, traditional approaches, when sentencing an Aboriginal offender. So those are my two comments.
Judge McCauley, do you have anything you'd like to add?
Well, Judge Brass said it perfectly, and Judge Reese said what I was about to say, so shame on you. But I'll add one more point here. We need something more. And I was looking at, and I had been researching about an Indigenous Justice Center in the north, where it's a bit of a kiosk, I guess, in terms of all the services, the resources that are needed for the northern, kind of like a northern center, because we have that in the cities, but we don't have that in the north. We don't have a domestic violence court. We don't have an intensive treatment center. We don't have an Indigenous justice center. There's such a big gap there, and unfortunately, that's where the biggest problem is in the north. and it moves into the cities, and then these addictions become so untreatable. It gets to a point that we need to get them before it gets to the crystal meth, into the fentanyl. We have to try to get them first. And another thing too is in terms of Judge Brass had mentioned this about the Indigenous lawyers. It takes an Indigenous person to reach an Indigenous person. It's not all the time, but it's a more of a profound communication. I've walked into the court in Prince Albert, and I'm sitting there, and there's an Indigenous person in front of me, and they're shy, they won't talk, and I look at them and I say to them in Cree, "Ginena na gigaskita na ganena wen," is what I'm saying. Is, do you speak Cree? And you know, it's a transformation that takes place. They look up, their eyes open, they stare, they giggle, sometimes they laugh, and then they start talking to you in Cree. And all of a sudden, this really shy person becomes very outspoken. So they're kind of out of their element. So I think in terms of what Judge Brass was saying is, we need more Indigenous lawyers. We need more Indigenous crown. We need more Indigenous judges. And I know sometimes when we look in the pool of the Indigenous lawyers, we don't have a lot of that, the Dene, the Cree speaking, the Soto. So we shouldn't limit that. Can we not start in the policy of going into the communities and seeking out these people that do speak the language and have these amazing experiences, and curtail them into the law system and go and recruit them and bring them into the law system, because we have to do something. And I think sometimes we can't always be on the defensive. We need to be on the offensive. So I really appreciated what both Judge Reese and Judge Brass said.
Another question that came in is, how has the introduction of mandatory minimum sentences under Controlled Drugs and Substances Act impacted, if and how, conditional sentencing approaches are used in Saskatchewan? Maybe I'll start with you, Judge McCauley, and then we'll work our way. We are at, just so that you know, we are at 1:28. So
I will pass this over to Judge Reese. Thank you, though.
Well, on a personal level, I think most people that go to law school are pretty independent thinkers. And when they're lawyers, they're pretty independent. So when you become a judge, you don't like somebody telling you cannot do something. You bristle. So I don't want to get too political. And as Justice Sapinka said many years ago, judges don't need to behave like monks when speaking publicly. I think that the mandatory minimums should be done away with, and judges will find ways to impose fair and fit and proper sentences. And if they are not, they can be appealed, right? So often the mandatory minimums handcuff the judge. And when you're thinking about that sentence, you're thinking, that's exactly the sentence that should be imposed, but I can't do it. And unless counsel brings some kind of an application, the judge's hands are tied. So I think they should be done away with, and put your trust in judges to make good decisions.
thank you so much. At this point, I know we have a lot of questions in the chat. I'm sorry we weren't able to get to all of them today, but we really appreciate all of your engagement. Karen has put some information in the chat as well, so you can see upcoming sessions and other links and so forth. Thank you to today's speakers, the Honourable Judge Michelle Brass, the Honourable Judge Mary McCauley, and the Honourable Judge Pat Reese. We appreciate you taking the time to share your insights and how Saskatchewan's justice system is and is continuing to advance reconciliation. Round of applause, everyone. Thank you so much. If you've enjoyed today's lecture, please keep your eye on the JSGS events calendar, where you can see all the upcoming events being promoted, including on March 15th, JSGS is hosting a virtual career summit. This may be only of interest to you if you're a graduate or undergraduate student, or if you're in the public and nonprofit sectors. There's no cost to attend, and you'll have the opportunity to meet with employers at a virtual trade show, attend 3 presentations from employers, and do some speed networking sessions. So that sounds like lots of fun. You can also join us next week for our next session on JSGS's EDI discussion series, where our panelists will discuss deconstructing racism in the public service. And if you have any interest in JSGS MPA programs, we're hosting 2 information sessions on March 29th. So again, all of those links are in the chat. Please come join us. We love to have as big a group as possible to have conversations like these. Again, please join me in a round of applause with your Zoom hands and waves for our honorable judges today. Thank you so much and have a wonderful afternoon.